Welcome back to another episode of I'll Allow It Nevada, your insightful podcast for valuable information into Nevada's judiciary. I'm Anne-Marie Mayu, your host.
And I am Seth Beasley, your co-host. Together, we proudly represent the Supreme Court of Nevada Administrative Office of the Court's Judicial Branch Training Unit.
You know, the Nevada Supreme Court AOC mission statement begins with this statement. The Nevada judiciary, as an independent branch of government, provides fair, efficient, and timely justice for all. This timely justice is what we'll be discussing in this podcast. Time to disposition and age of active pending caseload. Seth, can you please introduce our esteemed guest?
Absolutely. Joining us today is Sheldon Steele, Administrative Office of the Court's Statistics Supervisor. Thank you so much for joining us, Sheldon.
Thank you for having me.
Age of acting pending caseload. So does the age of acting pending caseload refer to, and why is it significant for court management?
So there's a couple concepts that's going on here. So active cases really just mean cases that are actively pursuing disposition. And a pending case is a case that needs to be disposed. So the age of active pending caseload is just that. How long has this case been aging that is pending disposition? It's really a time metric that allows the courts to see how many cases need to be disposed. It's a baseline metric for their future workload. From a litigant's perspective, they file a case. This is how long since the case has been filed that it has been unresolved. But again, for courts, the significance really is this represents a number of cases potentially requiring court action in the near future.
With this tool, this concept, the age of active pending caseload, this applies to all cases, correct? It doesn't matter what it is.
Correct. Taking it a step back, for our unit deals with the Uniform System for Judicial Records, the USJRs. And so what a case for us means something that follows either a complaint, a petition, a citation in terms of summary eviction. It could be an answer coming from a tenant. And it could also be an application for a protection order. But yeah, generally it applies to all court actions that are following those filing documents.
Okay, that makes sense. So how does maintaining accurate records of pending cases help to ensure timely case resolution?
Cases have life cycles. That is that they have these initial pleadings, they have motions, they have counterclaims. They have all these moving parts until the parties actually reach agreement or ultimately these cases go to trial. So not having accurate records can tangle this process up, or at the very least cause some sort of delay for the litigants to proceed to the next step. And so keeping these accurate records, some court processes, they're expected to be resolved rather quickly. I already mentioned protection orders. Domestic protection orders, for example, are often issued the same day as when the applications are filed. So these metrics allow the court to see how far along these cases have aged. So having a domestic violence protection order, for example, age greater than 30 days, while this is possible, it's not an expected outcome. And having these metrics allow the court to first identify these cases and then review to see if there's some sort of missing data entry, or at the very least, if there's a future hearing date scheduled to help this case proceed to disposition. So without an accurate record, hearings can be set for actions where the parties are not yet prepared, which typically would result in a continuance of that hearing type, which then can affect other cases that have hearings scheduled that same day by limiting that amount of time for those cases to hear those matters. And again, not all cases are going to be timely resolved. So while most CMS or case management systems have reminders for clerks to review these older cases, this metric allows them to see within perspective of the process or the specific case types to ensure that they're moving towards the expected timeline, through the expected timeline.
Okay. So are the timelines set as expected? I mean, are they loosely set, or is there a specific deadline that this has to be resolved within this amount of time?
So there are some statutes for when hearings have to occur, or minimum standards until they occur, but generally, outside of statute or specific court rules or the civil rules, there are no general legislative prescribed standards. So the National Center for State Courts does publish the model time standards, and those are really, really excellent to use as a baseline, but courts really should be evaluating these processes to ensure that they have expected timeframes for them.
So as far as calculating the active pending caseload, it sounds like it's simply from the time it was filed to now. So what tools or systems are used for that measurement?
You are absolutely correct. It's just from filing to now. And so typically these are calculated directly in the case management systems. We do not expect clerks to go into every case file, figure out the date that it was filed, and do that hard, complicated date, time, subtraction, measurement to figure that out. But it's typically done in the case management system.
So how do periods of inactivity beyond the court's control affect the measurement of the age of active pending caseload? How are they accounted for?
And that's where the case management system really comes in, because when we're saying things are out of the court's control, really we're talking about stays, warrants, or pre-adjudication diversionary processes. These have things outside of the court's control that prevent cases from actually moving to disposition because they have to be resolved first. In the case of warrants, the person has to be returned to the court to actually proceed on those matters. So what the case management system does is you have that begin time period, say, where the warrant is issued. And then when the warrant is either quashed or returned, that's the end of that time period. And it'll exclude that amount of time from the age of active pending caseload metric.
And so how can courts utilize this data to improve their operations? And do you have any examples of how this data has led to actionable improvements in case management?
Yes. So USJR reports these cases in bins. And so for original actions, these bins represent cases that have been active for 0 to 90 days, 90 to 180 days, 180 days to a year, and a year plus. The biggest improvements that we typically see in our unit is when these metrics are first being implemented. Not all CMSs can calculate these, and it does take time to program them in. But when they do become available to courts, what we see is the courts are currently reporting pending caseloads. But when the time metrics, these age of active pending caseload bins come into place, they realize that some of these pending cases are actually really, really old. And so what the courts end up doing is they review these cases and they realize that, hey, some of these cases we're missing some data entry and we're not actually pending. And once they're identified and corrected, courts go through that cleanup effort, and it's extremely time and energy intensive. And courts typically stay on top of this. They learn what these metrics are representing, and they actually that case review just starts being part of their everyday process. And so courts really should be using these bins to ensure that not too many cases are unexpectedly aging. We already talked about TPOs where cases are expected to be disposed rather quickly, but this can also affect other processes where statutorily cases have predefined steps for disposition, such as summary evictions, which are delegated through NRS Chapter 40 and the civil rules, and even guardianships, where we expect the guardians to be put in place rather quickly. That's a relative term, of course.
So it sounds like there are some challenges in managing and reducing the age of active pending caseloads. Let's talk about a few more challenges with that and what approaches the courts have adopted to address these challenges.
Yeah, so the key challenge really is data entry needs to be correct. First, you have to identify that the data entry is not correct, and then processes need to be adopted to ensure that these typical data entry issues do not occur in the future. The big one is making sure that you're dating the dispositions in the case management system and you're dating them correctly. For systemic issues, though, which isn't a typical situation for Nevada courts for original actions, but it does occur, clerks and administrators and even judges need to review these with the expectations that we expect most cases to be newer. And as time moves on, we expect cases to drop off this age of active pending caseload by being disposed. And as you're looking at those bins that I told you about earlier, we expect the fewest number of cases to be in the older ones, the 6 months to a year or the year greater bins. Sometimes, though, courts will have many new and many old cases, but the middle bins are the fewest in comparison. Generally, this is not an expected outcome. And when cases are aging that are not in line with expectations, their case flows and processes actually need to be reviewed. This could mean that data cleanup has not occurred or clerical time needs to be afforded for case review in the case management system, and not necessarily in the processes. However, sometimes it does occur, and albeit it's not an optimal one. We see this situation a lot in the justice courts where we have lots of new and older cases and fewer middle cases in justice court collection cases. Often what happens is these are filed and the litigants are the ones that just do not do the follow-up on what they need to do to let the courts dispose of the cases. And that's where process evaluation or the reliance on the civil rules becomes important to get those cases to be disposed.
While we pause for a quick break, I'd like to extend a special invitation to our listeners. I'll Allow Nevada goes beyond just being a certified legal education podcast. It's designed to be inclusive, welcoming all who are interested. We aim to build connections within our communities and provide valuable insights into the Nevada judiciary. If you've enjoyed our episodes, we encourage you to spread the word and share this experience with your friends and family. Your support is greatly appreciated. Okay, so we're going to kind of shift the topic now to our next discussion point, which is time to disposition. So can you explain a bit about what time to disposition means and why it's an essential metric for courts?
Time to disposition literally is just the end of case aging. So as you can imagine, that we were talking about the age of active pending caseload. Well, this is where the cases stop aging. At a very high level, this is how long it took for the issue being asked of the court to actually be resolved, less any time the case was out of the court's control for disposing. So it's an essential metric. On the Nevada Supreme Court's website, one of the key things that's stated on the website is that the Nevada judiciary has responsible to provide impartial, efficient, and accessible dispute resolution in legal matters. Really, for the courts, the time to disposition is interpreted by the litigants, participants, and public for how efficiently these cases are being resolved. But for the courts, the other side of this argument is how effective cases are being resolved. Now, that is another conversation, but really, we're merging this efficient and effective case resolution together to get this metric of time to disposition. So the Canada Department of Justice, when they're talking about effective case management, their quote is, "It is ensuring that every step of the process contributes to a just result by working the way it is intended to work without waste." And that really leads back to the efficient portion of this time to disposition metric.
So, what are the established timeframes used to measure this time to disposition, and how are the standards determined?
Yeah, so we touched on this earlier, but Nevada doesn't have a cheat sheet, nor does it have general legislative prescribed standards. It just doesn't. Courts are bound by statute for some actions. They can use specific civil or court rules for administrative closures. But when in doubt, courts really should be using the model time standards that are published by the National Center for State Courts. From a very high level, it gives good guidelines of how long it should take for certain case types to be disposed. For example, felonies, they say it should take a year for 98% of the cases to be disposed. Misdemeanors, 6 months, and traffic within 90 days, which is real interesting considering that we had AB 116 a couple years back by the legislature that introduced civil infractions. And it aligns perfectly, because if there is no answer to those civil infraction citations, they should be sent to collections at 90 days, which is in perfect alignment with those model time standards. And they have this for general civil, which is a year and a half, summary matters in civil within 6 months, which is where a lot of those justice court civil cases fall. They give other standards such as divorce within 4 months, protection orders within 30 days, and guardianships within 90 days. I mean, they've done the research for the courts already, and so courts should be using these as their basis and then tweak them to what is reasonable within Nevada standards.
Okay, so how can courts use this data to improve their processes? And do you have any examples?
So the time to disposition should be used to identify issues slowing down case resolution. But this assumes that the standards are known, measured, and reviewed. And really, that last one is the key, because reviewing statistics can be tedious. And then unless you are a numbers person, it can be a struggle not to get the sleepies in the process, The end goal, though, is improvement, and that's identifying that there is a potential issue and then hunting down for any cause. In the past, there was an issue with blood draw tests for DUI cases that were taking more time than anticipated. This was slowing down the cases, and so the time to disposition metric gives you a measure that says, okay, we expect these DUI cases to take 6 months. Why are they taking 8 or 9? This metric is what can be used to identify objectively that there is something slowing down these cases. But more importantly, these time to disposition metrics can be used to measure improvements. So when courts implement alternative disposing methods, such as mandatory mediation, or they improve their websites for self-help, they can use these metrics to see if the new programs had their intended effects of improving the time to disposition metric. So really, the time to disposition is a process measure. It is not simply the court's responsibility to improve upon. Litigants also need to do their part by being prepared and doing what is expected to move the adjudication process along. But they need to be informed that that is their role. Not all people have legal representation, and self-help resources can actually aid in this process.
And you can't ever talk about improvement, Sheldon, without also talking about the different challenges. We kind of covered that with the age of active pending caseload. Can we also talk about if there are any different challenges with the courts in meeting the time to disposition, and what strategies or tools that you know of have proven effective in overcoming the challenges?
Yeah, they do both share the same issue where data entry is the biggest challenge. Many case management systems typically have the statistics and the metrics as an afterthought, and the data entry process really reflects that. For the courts to report these statistics, the clerks need to navigate multiple screens to ensure that the systems can report correctly. For example, in criminal case, clerks might need to enter criminal charge disposition and their dates, but they might also have to enter when the case itself was disposed. And missing the case disposition might not indicate that there's any issue with these cases, but without it, the system doesn't reflect that the case was disposed, which keeps its status as active, which results in an incomplete record. Now, if they're using the age of active pending caseload, they can identify this and then go into the system and correct this case or cases. And upon correction, if the original disposition date for that case isn't entered correctly, meaning it's not backdated to the actual disposed date, then the system will report that later date, which will result in a larger time to disposition than what actually occurred. And that results in an inaccurate record. For overcoming the challenges, first, the administrators, clerks, and judges must understand what the metrics convey. Looking at a singular case is pretty easy to understand. It's X amount of days to dispose. However, often reports, much like the USJR reports, they give a median number of days to disposition for a group of cases. And this is a little more difficult to interpret. So it's important to remember when looking at these metrics, if you have a summary eviction mean time to disposition was 30 days, you need to remember not all cases took 30 days to dispose, but it also means some cases took even longer than that. So when you understand what the metrics represents and when the data entry is actually correct, the hard work really begins. And that is identifying the potential slowdowns in the business processes and finding their solutions.
How do local courts compare their time to disposition metrics with state and national averages? And do you have any insights or have you observed any trends on this comparative analysis?
So I really don't compare time to disposition metrics for the courts. I really just use the baseline metrics to evaluate how courts are functioning and if they are reporting within the expected timeframes. The court shouldn't view this as a competition. It shouldn't be used as a negative thing, because really what these metrics are used for are to determine if they're functioning as a high-performing court. Staffing levels, dedicated IT departments, and even case management, case cleanup, and even litigant behaviors can all be an effect on these time measures. And they're really a snapshot. If you're looking at it from a month, you might not have had as many cases to dispose, or you might have had too many cases disposed in previous months and you have a slowdown. These time metrics help identify what's going on in the courts. Now, in the off chance that you are comparing between courts, you really need to ensure that you're comparing the same process. So if you're looking at, say, small claims in Nevada to small claims in another state, you really need to ensure that baseline that you're talking about the same monetary values, that you're talking about the same sort of rules that are applicable to both processes. It's not just limited to small claims. You could have alternative sentencing departments. You could have dedicated juvenile probation departments. You could have mediation. You could have all sorts of different programs that are in place to improve your time to disposition. Now, from the state viewpoint, I did recently review the district courts as a whole for last fiscal year, and I did compare those with the National Center for State Court Model Time Standards. And yeah, I'm just going to say the state is doing awesome at the district court level. What we've really found looking at the entire year, that felonies on average, when I say average, I mean the mean, were disposed in approximately 6 months, whereas the standards say 1 year is the expectation for 98% of felony cases being filed. We found that most major civil case types are also disposed within a year, where 1.5 is expected. And probate cases were being reported as disposed within 84 days, guardianship cases within 78 days. I mean, they're doing really, really well.
Well, that's great.
Yeah, we love to hear that. They're more than meeting those national standards. They are surpassing them.
Exactly. And without these time metrics, you can just say, hey, we're doing awesome. But now they actually have a measurable magnitude that can say, this is what we're doing, and we're doing well.
That's awesome. Yeah, thank you. So to kind of wrap up this conversation, can we just kind of discuss the interplay between age of active pending caseload and time to disposition and how these metrics complement each other?
Oh, of course. So the age of active pending caseload really are the cases that are coming to disposition. It allows courts to have an idea of the resources required to get these cases disposed when combined with the expectations of how long specific case types should take to dispose. The time to disposition is the end result. How long did they actually take to dispose? And when you add in another metric, which we haven't discussed today, it's called the clearance rate, and it's really just a ratio of outgoing cases to incoming cases. It really gives you a good picture of how the courts are performing.
So, Sheldon, consider the impact of these metrics on different stakeholders, including judges, court staff, attorneys, and the public. How do the metrics enhance transparency and accountability?
Remembering what I said at the beginning, outside of court personnel, the main perception for many people is how long these cases took for the court to find resolution. I remember years ago, we were doing an access and fairness study outside specific courts, and we were asking set questions for people who just had their cases heard. And yeah, so while not everyone had their desired outcome, and yeah, they were very vocal about it at times, most people indicated that they were given their chance to be heard by the court, and it was done in a reasonable amount of time. So it really goes back to the saying, the Nevada judiciary has a responsibility to provide impartial, efficient, and accessible dispute resolution in legal matters. And by having these metrics, it ensures that even the most difficult of cases is not swept under the rug, and it provides a tangible metric for how the courts are performing, and it's based on time. I think that's how they really enhance the transparency and accountability.
So just one more quick question. So thinking ahead, do you know of any future trends or innovations in court case management? And what advancements do you see taking place in the coming years that can further enhance the tracking and improvement of these metrics?
Yeah, so I wish I had the crystal ball that could tell you exactly what's going to happen. I will say that over the past few years, the case management system vendors, They are definitely taking these metrics to heart, not necessarily the statistics portion, but the metrics to heart, and they're making it a priority for the data entry to be easier. So I'm hoping that trend continues and we see more ease of access that way. From our unit's perspective, we are working on a data repository. A data repository is a total shift away from the current USJR model. And what the USJR model really is the courts provide all these metrics. They lump them up in aggregate, and then they provide it to our unit on a monthly basis. Well, what the repository is actually going to be is this, it's a lot of the same information, but it's going to be the actual case dates of when they were filed, when they were disposed, when they had a hearing. And that's going to give the statistics much more robust meaning. And in all honesty, it's going to be a complete reversal of what it is today, where the courts are giving us the statistics. What's going to really be happening is they're going to be giving us these dates and these major events, and we're going to be providing them the statistics to use. It's going to be a complete reversal in roles, and I'm really, really excited to be a part of this effort. And finally, I hate mentioning it, but in the next 5 to 10 years, AI is going to be part of this case management process.
Oh, yeah.
And what that looks like, I don't know. I of course, don't anticipate that we're going to have AI handing out sentencing and making adjudications. But, currently we have a disparity between rural and urban courts in just the size of the IT departments and what the IT departments can do. I can truly see AI bridging that gap where AI can help identify breakdown in certain court processes or even missing data entry and sending email reminders to the clerks or administrators or even the judges for future hearing dates, doing those reminders that are more afforded currently to courts that have much larger IT departments.
That will be really helpful. And, when we talk about innovation and improvement in our courts, you, Sheldon, and your staff certainly have a huge part in that, because we don't know what we need to improve until, you've looked over the data and kind of have given us that report, and that goes, from the Supreme Court all the way down. So it's really helpful, and we truly appreciate all of that you do and the information that you're sharing today. Is there anything else that we missed? Is there something else that you are interested in sharing that we just forgot to ask you about?
No, but for the listeners, if any of these topics are new or they seem very complicated, I would highly recommend anyone going to the National Center for State Courts website and reading about the core tools, the Court Statistics Project, or you could even go to our statistics unit's webpage and review our data dictionary. All this is laid out. These are the expectations, and they aren't just make them up. There's been a lot of thought. There's been a lot of feedback from the judiciary and their stakeholders into getting to where we are today. And so I would encourage everyone to review these materials.
Wonderful. Thank you for those resources.
And Sheldon, thank you so much for joining us today and speaking with us about these metrics. We really appreciate your time.
Well, thank you for having me.
A big thank you to our guest and to all of our listeners for tuning in. Before we wrap up, here are a couple of important reminders. To earn continuing legal education credit, be sure to submit a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. We welcome your questions, topic suggestions, and comments. To share them with us, please email us at jepodcast@nvcourts.nv.gov. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada, released every first and third Friday of the month. This is Seth Easley signing off. Take care, Nevada.